But now for our interview with the Honourable Dr. Jocelynne Scutt AO. Now, Jocelynne is a former judge, an anti-discrimination commissioner, and was also chair of the CEDAW People's Tribunals. Jocelynne, thank you very much for joining us today. We've got a lot of things to talk about, haven't we, affecting 1950s women and issues that are current?
Yes, indeed.
Now, the judicial review out at the Govan Law Centre on Winterfield Lounge, I think you wanted to say something about that, didn't you?
Well, it is interesting, and I understand that there's another group that's instituted a judicial review as well. I mean, if they're on the same topic, then the courts would be reluctant to have two judicial reviews going on the same topic, but they might join them in some way. But it just does seem very strange that the government has introduced this change, because it will impact on 1950s women in particular, because they're already suffering because of clawback, effectively, of the money to which they were entitled as a pension. And also there is the issue that, generally speaking, people recognise that universal benefits are a positive way to address need, in fact, because people who don't need it often have the graciousness to give it up or not to claim it or give it to charity. Now, some people hang on to whatever they can, that's true, but one of the other aspects of universal benefits is that nobody who's on the edge, because they're getting £1 extra, they're cut out from a particular benefit. And another thing about having a universal rather than a targeted benefit is that with a targeted benefit, you actually do put people in a position where some of them will take what opportunity they can to not be truthful, because they want to manipulate the situation in order to gain the benefit. And it's not really the best thing to put people in a position where they might want to take advantage in that way, because you're effectively creating a dishonest group that wants to take advantage. And then the final point is that universal benefits don't have an administrative cost that relates to checking whether people are actually entitled or not. And therefore, the opposite applies when you have a targeted benefit, because you've got to introduce an administrative program which costs money to make sure that you're targeting properly. And this really gets us onto the issue of the Ombudsman's report. And it appears that the Ombudsman report, different issue now, of course, but there's a similarity here, because the Ombudsman report in relation to the 1950s women seems to be suggesting that, number one, women have to make application themselves to the Department of Work and Pensions to make an argument that they are entitled to redress of some sort. And that entitlement has to rely on their being able to prove that they weren't notified or weren't notified within a particular time. Well, of course, it's extremely difficult to prove a negative. And it's the Department of Works and Pension which has that knowledge. And we know from the experience outside, from the evidence that was given to the People's Tribunal on CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, and the People's Tribunal that was held on the actual pensions issue, we know that there were very few, if any. It was rare for the women to be notified, and to be notified with proper notice, that was even rarer. And to come back to this point, if you implement a system, as appears to have been proposed by the Ombudsman, that A, the women have to make a claim to the Department of Work and Pensions, then you're putting an onus on the women that they ought not to bear. The government should bear the onus, because it's the government that's done the wrong thing, number one. Number two, how do they prove that they weren't notified? Number three, and that information is within the bowels of the Department of Works and Pensions, you create a position where the Department of Work and Pensions is yet burdened further with an administrative responsibility to work out who gets what after all these applications come in. Now, we know from experience that the Department of Work and Pensions does not seem to have the capacity to deal with yet another issue, of having to work out administratively who's entitled to what. Because really, with all the greatest respect to the department, and I have great sympathy for all the bureaucrats, the civil servants who are working there, because they seem to be working under extreme conditions, but not a week goes by when we don't hear that the Department of Work and Pensions, there's been some other problem, and there's a group that hasn't got this, there's a group that hasn't been paid what they're entitled to. I don't think we want to put another burden on the Department of Work and Pensions, as appears to be the suggestion in the Ombudsman report. It doesn't seem to be wise. If I may put it this way, there appears to be not inconsiderable unwisdom in the Ombudsman's report, with the greatest of respect to the Ombudsman and all who worked on that report.
I want to ask you about ratified CEDAW International Law General Recommendation number 40.
Oh, yes. Well, General Recommendation 40, I actually went to Geneva some months ago, I think it must have been about May, to make a submission on General Recommendation 40, as of course did a number of other women from this country and from elsewhere. And General Recommendation 40 is being put forward by CEDAW, the Committee of the Convention on the Elimination of All Forms of Discrimination Against Women, to make indisputably the principle to turn into the practice of all governments who've signed up to CEDAW, that women must be at the table. Women must be centrally involved in discussion and policy making, the formulation of practices, of rules, regulations, and laws, and so on, where women are impacted. Now, we know, of course, that there's not a law that's passed in this country. There's not a practice that comes into effect from a government or bureaucracy, and there's not rules that are not relevant to women. Everything's relevant to women. Land law is relevant to women. Tax law is relevant to women. The laws that the government passes in relation to pensions are relevant to women. Everything that government does is relevant to women. And what this General Regulation 40 is saying is that governments have to ensure that women are equally involved, that women have leadership roles at every level of decision making within government. And then, of course, there's the issue of the private sector too, where the same regulation or rule or recommendation, General Recommendation 40, should apply as well. Now, about 2 weeks ago now, Friday, I think 2 weeks ago, they implemented the General Recommendation 40 has been accepted by the CEDAW Committee. It is now on the table. It is now in effect. And this country, like all other countries who've signed up to CEDAW and ratified it, this country is obliged to follow it. And if we come back to the pensions issue, one could only hope that the government would obey, would actually see its way to ensure that it does live up to General Recommendation 40 in relation to the efforts that are being made by the women, at least, to ensure that this pensions issue can be resolved effectively, efficiently, promptly and fairly with justice.
Thank you, Jocelynne. I wanted to ask you about the CEDAW Article 8, the optional protocol.
Yes, well, the optional protocol to CEDAW, the convention, says that if women have taken an issue under CEDAW in relation to discrimination against women on any of the bases within CEDAW, the articles within CEDAW, and they've taken it through the domestic realm, the domestic courts, then they can go to the CEDAW committee and ask for the CEDAW committee to address the issue. Now, 1950s women, CEDAW in law, have done that. They have taken the matter of the failure of the government to engage in mediation. They've taken that and the entire kit and caboodle, really, the basis on which that proposition was put forward to government to resolve the matter, the lack of notice, that is maladministration, and the direct discrimination involved in relation to sex and gender, and the direct discrimination involved on the grounds of age. and that is now before the CEDAW committee, for the CEDAW committee to make a determination as to its assessment of the impact of maladministration and the direct discrimination that the women have suffered. Just as an addition, I might say there also is a basis for arguing that there's some indirect discrimination too, because what happened to women, we know this from evidence given to the People's Tribunal, and in the report from that tribunal, we know that there were women who went through divorce proceedings, and when they went through the divorce proceedings, the property and settlement in relation to money was made on the basis of the assumption that they would get the pension at 60. Now, the women didn't know that they wouldn't, and it appears that the lawyers didn't know, and it appears that the court didn't know. So therefore, there is potential indirect discrimination there because they were impacted differentially by on the grounds of family relations or coupledom that was ending via divorce, and that argument could be made as well.
Yes, that's important. So we await the decision, the final decision on that, I suppose.
Yes, and there is another avenue that has come to attention in relation to the Human Rights Committee. There's a possible avenue there that's being explored. I can't really speak for them, but I understand also from CEDAW in law that they are reviewing the judicial review that was instituted, where the aim of it was to get the government to the table in relation to mediation, and it was put on hold, it was suspended. But the lawyers whom they instructed were clearly of the view, that they put this in writing, that the failure of the government to enter into mediation, well, it was unlawful. That was the view of the lawyers instructed by CEDAW in law.
Now we're going to move nicely on to mediation, actually, because this is the letter to the Secretary of State for Work and Pensions, isn't it?
Well, I mean, it'd be comical, really, except that if it weren't so serious, that the letter that came from the Department of Work and Pensions saying that they couldn't quite understand why the proposal was coming from CEDAW in law for mediation. And one of the bases they put that on was that you can't do mediation without having instituted legal proceedings. I mean, you don't institute proceedings in order to approach another party and say, we would like to mediate on this particular matter where there is a clear dispute. There can be no dispute that there is a dispute between the government and between the women who were born in the 1950s in relation to this issue of pensions. It would be ludicrous to suggest there's no dispute. Well, there is a dispute, and therefore the way to resolve the dispute is to come to the table and engage in mediation. That's a sensible way to deal with it. And it is really unfathomable as to why the government is resisting this and sending letters through the Department of Work and Pensions to say, well, we can't do mediation because you haven't instituted legal proceedings. So that they seem to think that 1950s women have to institute legal proceedings, engage in the expense that that entails, and run the risk of being put to further expense of further legal costs and so on, before the government can see the sense of mediation. As I say, it's unfathomable and it's extraordinary, and it's not consistent with what the law is. That's number one. Secondly, they've said that the matter had been resolved, that there was no direct discrimination at all, because they said that there had been an earlier judicial review run by the organisation that was the precursor to CEDAW in law, and the High Court addressed discrimination, though their view was that there was discrimination against men, not women, which is, again, not readily understood, because the men were not impacted at all by the 1995 Pensions Act, which raised the age of women from 60 to 65. Men were 65 all along. There was no change to their position then. There was a subsequent change to 66 for everyone. But what the court was saying was that the men were discriminated against. And as I say, they might have been discriminated against back in 1940 when the Act came in and made the distinction between women and men 65, women 60, but that was not the matter before the court. So that was difficult. Anyway, the High Court dismissed every ground, but they granted leave to appeal to the Court of Appeal. Therefore, the lawyers representing this group in the judicial review went to the Court of Appeal and argued all those grounds upon which leave had been given. Now, again, it's true, the Court of Appeal held against them on all those grounds, but again, the Court of Appeal gave leave to that group to appeal against the Court of Appeal decision. The Supreme Court, in a one-liner, did not address any of the grounds that had been referred, but actually addressed a ground that had not been referred, and that said that it was out of time. Now, that's being used by the Department of Works and Pensions to say that the matter of direct discrimination and so on has been resolved. Well, I would actually contest what they're saying, because you see, they're then effectively tossing to one side the Supreme Court decision, which is the top decision, and reinstating the Court of Appeal decision. But the Court of Appeal decision, in a sense, has been vacated because they gave leave to appeal on all those grounds, and it went to the Supreme Court for all those grounds to be litigated. And so I would say, I think it is an interesting legal question, and I think it's one it would be interesting to debate with whoever the lawyer is in the Department of Work and Pensions who's trying to reinstate the decision of the Court of Appeal when the Supreme Court looked at the issue from out of time, which of course was, again, with respect, untenable, because in the court below, when the original judicial review was lodged, the administrative division of the court said that it was not out of time, but said that to cover all bases, extension of time was granted. And then the other point that was made in this letter that came from the Department of Work and Pensions was that, which sort of contradicts their view that there's no dispute here that the CEDAW and law is involved with, they said that the matter was already before the Parliament and the government because of the Ombudsman report. Well, if that's so, the matter's already before the government because of the Ombudsman report, then that really seems to contradict their proposition that there was no dispute for the CEDAW in law to be requesting mediation on. And it also means that what they're saying is there is something to have mediation on, namely the maladministration. And if maladministration is going to be addressed, then direct discrimination or discrimination needs to be addressed as well, because that's in dispute as well. And it would be wise, in my view, for the government to recognise that this matter has been going on too long. It's a superating sore. Women who have been impacted are dying, and women who have been impacted who aren't dying are in grave financial difficulty. Now, you might find the odd woman, in terms of numbers, who will say, well, I haven't been impacted at all because I'm actually fine, I don't need that pension. Well, I'm very pleased that they don't need the pension, but that doesn't then answer in terms of all the women who do and who paid in money. They paid their money in via the National Insurance Scheme, and they paid the money in on the understanding and the expectation that they would be paid out their pension. And that's not what happened. And so they have a legitimate expectation that also is an issue in a judicial review that can be considered.
Yes, now one of the other things here was there was something I think was wanted to be implemented was the CEDAW temporary measure, temporary special measure.
Yes, temporary special measure is in CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, because what it recognises is that when you're trying to effect equality between women and men, there may be measures that are necessary to introduce to support women in some way, or to recognise that women are not yet, as a practical matter, equal. Because if we go back to this pensions issue, you see, saying, right, we're going to make women retirement age at 65 is assuming effectively that women and men were in the same position and would be in the same financial position at 65, and that between 60 and 65 they wouldn't be suffering any detriment or harm or damage. But the reality is that women who were born in the 1950s very often left school at 15 and went into work, whether in a factory or in the post office or in a shop or in some other job that was not a highly paid job, that didn't carry, for example, a private pension with it. Some of them were more fortunate. Some of them did go to university, but not all that many of them. And there does seem to be a complete and abject failure to recognise the realities of discrimination against women who were born in the 1950s and who were expecting their pension at 60. Now, the temporary special measure is a measure that can be taken to deal with and to address a problem that's arisen because of discrimination against women. And that means that you have to actually redress by giving some benefit that's not an inappropriate benefit, but a benefit that men aren't going to get, for example. And what's being proposed here as a temporary special measure is that to effect a fair outcome that redresses the 1950s women position, because they were targeted in the transition from 60 to 65, there should be introduced this scheme that there would be payment of an initial lump sum for each identified woman, 1950s woman, who had been affected and impacted by this change. And you can easily find out who they are because you go to the schedule to the 1995 Act and then to the schedule to the 2007 Act, which had some slight differences in it. But if you go to those schedules, you find out how the women were impacted, because there were some that got the pension 3 months after they turned 60. There were some who got the pension, say, a year after, 2 years, 3 years, 6 years after they turned 60. So that you can look at that schedule and you can see absolutely who's been impacted by their date of birth. It's all in there. And so you can see who's impacted. So those who've been impacted should be paid an initial lump sum. And that lump sum, obviously they're not all going to get the same lump sum, because you, again, can work it out. It's not hard. There's no great shakes for the Department of Works and Pensions to put a whole lot of effort into this. It's absolutely clear. You go again to those schedules and you work out the lump sum. There would obviously be a smaller lump sum for somebody who was just impacted for 3 months from somebody who was impacted for 6 years. It's clear and it's not difficult to work out. So there's this payment of an initial lump sum, and then there would be additional payments atop their state pension payments paid out over, say, a 5-year period, again on a pro rata basis, worked out in accordance with the schedule to the 1995 Act, and then for those who were affected by the schedule in the 2007 Act. And that would be entitling them to this lump sum and the top-up compensation equal to the sums that were deferred. And that is something that would be on the table for negotiation with the government. The second point would be that there would be no tax payable on this lump sum and the top-ups. The benefits that the women are receiving currently would not be affected, and there would be free dental, optical services and prescriptions, and then a named benefactor if, in the event of death, to somebody who had not received all the outstanding monies. And just coming back to this free dental, optician services and prescriptions, you see, what we actually know about the 1950s women is that because of their age, a not inconsequential number are in difficulties in health terms. We know also that the National Health Service is being impacted by being overwhelmed, as one might say. So if these women were to receive free dental, optician services and prescriptions, then their health would be improved and they wouldn't become a burden on the National Health Service, which none of them want to become. Nobody wants to become a burden on anybody, and in particular on the National Health Service. So this is another way to alleviate the National Health Service. And it's a preventative rather than having to do something when somebody's ill. And then finally, mediation does require parties to enter into it in good faith in order to reach a compromise in terms of what each side is saying. So the 1950s women, the Cedar-in-law, it's simply saying to the government, we want to come to the table. We've got this worked out, what we think is a fair resolution way to resolve this dispute. Will you please come to the table so that we can sit round the table and have a discussion with our proposal on the table and whatever you're saying, and then we can work out a fair outcome. And I understand, I've been advised by Cedar-in-law, that Garden Court Chambers, who are specialists in mediation, are at the ready to be an independent mediator. They would be completely independent from Cedar-in-law. They would be completely independent from government. They're simply sitting there in the middle to ensure that the parties can engage in mediation. And that's an offer that should be taken up by the government, because this dispute needs to be resolved, and it needs to be resolved promptly and fairly and with justice. And the current government should, if I may say with respect, take this opportunity to do just that. Now, the Women's Parliament, this is carrying on a tradition that women here and in Australia and possibly in other countries established when we were in the fight, the struggle, the campaign for the vote. And what the women decided was that they would hold parliaments, because they said our voice is equal to anybody else's voice. All those men in Parliament, they stand up and make debates and so on. So they did the debates about the right to be in Parliament, to speak in Parliament, to have the vote, and the right to stand and run for Parliament. And so I just decided that we should reinstate this tradition, and had the first one several years ago on International Women's Day, and it was held in the council chamber at Guildhall in Cambridge. I was a city councillor or a county councillor at the time, one or the other. And what happened was I made up a motion that CEDAW, the Convention on the Elimination of All Forms of Discrimination Against Women, should be implemented domestically by the United Kingdom government, because having into it by signing it and then ratifying it, they made an undertaking that they would introduce it into domestic law, and they haven't. I mean, what they're saying is, well, the former government, they said that they had to get Wales and Scotland and Northern Ireland to agree. Well, the point is that those three countries are already acting, endeavouring to get the CEDAW into their domestic law as their independent authorities under their authority power. And, well, the former government was saying, we hope this government's not saying it, what they were saying was that ratification doesn't mean that they have to actually introduce it domestically. And then they said, and anyway, we have another contradictory contention by government. And they said we have, because we've got the Equality Act and we've got the Human Rights Act. Well, no, they haven't, with respect, because there's much more in CEDAW that needs to be implemented domestically. And then in December, we had another Women's Parliament, and this was on violence against women, because it was during the days, UN Days to End Violence Against Women, and also International Human Rights Day. So we've done that every year. We've done it also in Sydney at the University of New South Wales. We had one at the beginning of this year in June, and we're having one on the 9th of December. It's the day before International Human Rights Day. It will be in the Moot Court at the University of Buckingham Law School, and we will have 25 women, each speaking for 5 minutes to a motion on the Beijing platform and declaration, which was signed up by this country and many other countries in 1995 at the conference in Beijing. And it's now 30 years next year, anniversary of the Beijing platform and declaration. And this motion will be to the government to say, please ensure that you live up to every obligation and duty that you signed up for in 1995, because in 2025 we want to be sitting here in the United Kingdom with everything that was said in the Beijing platform implemented by the government. So that's another thing that this new government can put on its table, and we will be passing this motion on the 9th of December in the moot court at the University of Buckingham Law School, with our 25 women acting as members of the Women's Parliament, speaking to this motion on Beijing plus 30.
Wonderful, Jocelynne. That sounds really good. I'm sure there'll be a brilliant event, and that's going to be past that motion. That's great. Thank you, Jocelynne, for joining us today. It's been lovely to speak to you again, and thank you for all the information affecting 1950s women and affecting other people as well.
Thanks so much, Ian. It was actually wonderful to see you again and to speak with you. I appreciate it. Thank you.